Yes, I'm ready.
The video has been turned on, sir?
Yeah. Is it fine now?
Yes, sir. We are able to see you. We are able to hear you.
Ready to start? You can start rolling.
Sure. Good afternoon, Honorable Professor Dr. Sudhir Krishnamurthy, sir, and all my court manager participants. We have gathered here for the part 2 of the webinar series from the distinguished guest speaker. I welcome respected Sri Professor Dr. Sudhir Krishnamurthy, sir, who is a Vice Chancellor NLSIU in this August platform. On behalf of all the court managers, I express my gratitude for providing his valuable time on this Sunday noon to share knowledge with all the court managers. Now I request Dr. Kalpesh Gupta sir to introduce Dr. Sudhir Krishnaswamy sir. Dr. Kalpesh,
Dr. Kalpesh may have been logged out. Maybe by
logged out. Yeah, yeah. Now he's online. Dr. Kalpesh, Kalpesh sir. Hello, Kalpesh sir. Hello, Kalpesh sir. I think there is a bandwidth
connection
issue,
issue.
connection issue. Yeah. Sir, with your permission, I would like to
We
recap.
can start because I've been introduced to your group already.
It is
We
your
could
so.
start. And I think it's more important to have the discussion we're having. We can go right ahead.
Thank you so much, sir. Thank you so much. With your permission, and I would request to start the session.
Thank you so much, Mr. Panchakshari, and thank you for the invitation. So I'm going to do two things today. I'm going to very briefly try and summarize what we discussed in the last session, and then move ahead to address what some of you had suggested would be an important way of thinking about the issues in India, which is to think about a concrete case study, in this case, Singapore. So I will spend maybe another 25, 30 minutes on Singapore. But before that, let me just review and summarize what we had discussed in the last session. So in the last session, we had looked at how the academic and policy literature on the question of justice delivery has been organized across the world, also in India. I mentioned that in India, the emphasis is almost exclusively on two questions: pendency and pendency delay and backlog. This is an old story. It has occurred in India at least for 200 years, starting with the early company courts. The reason we have these levels of pendency and delay may be some supply side problems. We don't have enough courts, not enough judges, but we also seem to have the idea that we will adjudicate every case that comes to hand in a court system. So we want to increase the number of judges, increase the number of court halls and supporting staff to process all the cases that get filed. I then looked at a few other measures of justice delivery across the world. We looked at the doing business in India, or the doing business World Bank surveys. We looked at rule of law indices. We looked at access to justice reports. Access to justice reports, unlike the rule of law index or the doing business in India index, they are demand side assessment, meaning they do surveys among the population at large and ask them what would they like the court system to do for them, and make an assessment on that basis. So, and I distinguish these kinds um, of measures, right? In the end, I looked at some ways in which we can think about judicial and legal policy reform. Um, I looked at one approach, which is to amass large data sets using data available either from courts that you administer or from the National Judicial Data Grid, these large data sets, and do some broad statistical analysis to look at reform. Other is to focus on very small case studies, institutional case studies, maybe the smaller courts, the consumer courts, the family courts, maybe even the tribunals of various sorts. Devise a form of reform that works in these smaller contexts and then scale them up. Right? So I looked at this range of options and I suggested that maybe the key in Indian legal system reform work is to understand that a legal system is a dynamic model. It's not static. So if you increase the number of judges, increase the number of courts, and process cases faster, more cases will be filed because there is pent up demand for legal services. I also suggested that a dynamic model anticipates that people's incentives are very different. So, for example, if you make more judges and you allow for more oral argument, you will actually process less cases. And what I found is that in a study on commercial courts that is to be published by the NUJS Law Review, what we have found empirically is that in Delhi, the establishment of commercial courts has actually led to, if anything, a slowdown in the rate at which cases are decided. Very counterintuitive conclusion, but it must tell us something about the complexity of how we think about legal system reform in India, and so that's where I roughly concluded. I said what's really crucial is to design legal system reform in a way that addresses the incentives of all actors. When we say all actors, we mean clearly parties who approach the court, their lawyers, the judges, and the entire registry and admin structure that accompanies the courts. These are the direct stakeholders. There are wider stakeholders. Executive government is clearly a big stakeholder. So too are the people at large, right? So stakeholders are varied. We must design a system that to the extent we can align the interests of stakeholders. This is the position that I was trying to develop. And this is what we concluded with. And there was a suggestion that I think concretely about a single case study that I can try and illustrate. That is what I'm going to do today. I'm going to focus on a case study, which is Singapore. Why Singapore? There are some good reasons to compare with Singapore, and there are some not so good reasons. Let me state the good reasons first. The good reasons are that Singapore, like India, is an Asian country, but has a British Anglo-Saxon legal system primarily, right? So, like India, Singapore inherited a British system and has retained it. Right? We are in a similar situation historically. Second, Singapore has training for judges and training for lawyers, which is very similar to India. So we are trained similarly. Our legal cultures both draw from English roots, and we are proud about that. So both jurisdictions have legal cultures that are quite similar. What is different about the two countries? Clearly, Singapore is a single city state. Its population is just a little less than the population of Bangalore as a city, and so it's you might say that the comparison is inappropriate because one is trying to compare like a subcontinental country like India, which has such diversity of issues, with a very small example like Singapore. This is where the comparison may be difficult, but you'll notice as I go along that I'm going to suggest that what we can learn from Singapore might actually cater to this diversity. So, what do we need what is the Singapore story? I mean, let me state the story in brief and then try and break down analytically what might the ingredients of Singapore's success be, and then work out some things that we might learn from Singapore. So first and foremost, what is Singapore's issue? In the early 1990s, Singapore was very similarly placed to India. For a small city state like Singapore, with a population of, at that time, it might have been about 5.5 million, it had more than 2,500 cases pending in its court structure. And the rate at which cases were being filed was rising. The rate at which cases were being disposed was falling, and they ran the serious risk that they would have an endless backlog, much like we have. What has happened in Singapore? What is the success story that they have? Today, they have the fastest recorded average rate of disposal, roughly about 167 days for a civil case in the first instance. They have a highly efficient court system, both in terms of, and here you must, and I'm going to close with this question once again, is an efficient court system one that will not be just? This is a big issue in Indian debates. And I'm going to close with this question. What is striking about Singapore is levels of satisfaction with the Singaporean court system are rather high. So let's take the two main success criteria. A, that Singapore has now almost eliminated its pendency of cases. We have reached a stage in Singapore that from about 2016 or something like that, I don't know, may not know the exact date, there were dates that were just simply treated as free days for the court because the court had disposed of all its cases. So Singapore has the luxury of saying that it manages its docket so well that the Singaporean Supreme Court may at times not even have to sit. And the second thing is that levels of satisfaction are rather. Now, how did Singapore manage this transformation? You know that now 2,000 cases is different from 3.2 crore cases, which is the generally agreed figure. Though I think post-COVID, we can safely assume that the level of pendency is going to go up. My guess is by an order of maybe about 10%. So you can safely add another 30 lakh cases, 3 million cases to the Indian system. We'll end the year with about 3.5 or 6 crore cases pending system wide. Now, we all know, and all of you as insiders in the court system know, that number counting in India is very, very weak. So, this is the best guess figure that we have, but the figure may be wrong. May have an error rate as high as 6, 7, 9%. I'm not sure. You probably have a better sense of that. So today in India, we have a huge backlog of cases. We have very, very low levels of satisfaction. So if we ask the average litigant, and I don't mean the litigant only in high profile matters before the Supreme Court, I mean the litigant in the average family law case before the family court or the average recovery suit in the civil court, levels of satisfaction are extremely poor. Average rate of disposal in India is also high. We don't have accurate figures, but let us safely assume that the lowest figure that we might settle with would be something like 11 months, 9 to 11 months. And here I'm going to say, very gracious figure to the Indian court system. I'm saying if I club all small cases, big cases, from traffic challan cases all the way to recovery suit cases, what would the average be? I'm willing to say it's 9 to 11 months. Most people would argue hard with me and say it's more like 18 months on an average across all cases. That is the situation we're in. We're roughly where Singapore was in the 1990s, probably by an order of magnitude 2, 3, 4 times as worse. Right? What can we learn from Singapore? So Singapore had 3 elements in their reform program that I'm going to pay some attention to. Now, a story of reform will have many, many elements, but I'm going to pay pay emphasis and focus on three of them. The first of these is that one takes a 360-degree view of the process of legal reform. I'll explain that. The second is that legal reform requires strong and steady leadership. Number two. Number three, I'm going to focus on some ingredients of reform. In particular, what happened with the integrated electronic litigation system that was in Singapore. What have the results been? How have they combined many strategies in an effective litigation system? So that's what I'm going to focus on. I think as court managers, many of you are interested in this question, and you probably already know a lot, and I'm happy to take questions and comments. But for the moment, I will take the lead and try and introduce these elements to you. So let me start with the first element, saying that effective reform is 360 degrees. In 1990, when this process began in Singapore, there were many things that needed to change. How do you change these many things? And I'll describe to you a little bit about how it was done in Singapore. First and foremost, you need to change people. How do you change people? You need to start selecting and attracting better people to both judicial services as well as to public prosecutors and so on and so forth. So the first thing they did in the 1990s is institutionalize a very strong judicial and court clerkship program. They got the very best graduates from various law schools around the country and integrated them into the court system at a very young age. And subsequently, very quickly, especially if the graduates were bright and well qualified, they were given an accelerated progression through the Singapore Legal Service. So Singapore has a national legal service which was created around the same time. And this legal service does most of the staffing of the judicial side. Number two, they set up a National Judicial College to do judicial training across Singapore. Previously, judicial training was left to the individual court to do, much like we do with the state judicial academies. Notice in India, we have a National Judicial Academy, we have a State Judicial Academy. Each state judicial academy pretty much runs its own program. They don't have an integrated calendar, and they don't have an integrated approach to thinking through questions of legal reform. Number three, and this is very, very important, they created a very significant new institution called the Singapore Academy of Law. The Singapore Academy of Law was very different from an ordinary law college. It was seen as a place where continuing legal education occurred for lawyers and advocates, especially legal education that allowed them to make a cultural change in the way they approach litigation. So, legal education for professionals. Second, the Singapore Academy of Law became the primary institute to do empirical legal research and focused research. How do you change notice and summons procedure in the Singapore courts? This was the kind of detail of the research that the Singapore Academy of Law would do. It would engage the best people that they could engage. They implemented these programs. It came from this institution, and as a result, it had high levels of acceptability and was implemented in the courts. So this deals with the personnel problem. The second element, the second ingredient of a 360-degree reform process must be that there is political support. So they set up, the executive branch set up a legal transformation institute, which brought together an executive funded program to invest in technology and invest in the transformation of the courts. And this they ran as a program for more than a decade and a half. This is a very important strategy in Singapore. The third element is that you have to invest in the right kind of technology. So Singapore, in a staggered sort of way, it initially began much like India did, I think, Though India began in eCourts 1 with a computerization program, just putting computers on people's desks, the Singaporean program focused initially on the questions of electronic filing. How do you ensure that courts are amenable to electronic filing as the basis for engagement with the courts? They have then migrated into version 2 of the program, which is an integrated electronic litigation system, which is far more advanced than just an e-filing system. For most of you, and most of you are already in the court system, and I'm sure you can tell me the details of where we are reasonably put. But my own understanding of where the court system are is that we have more or less worked out. Uh, we have the capacity for people to work on individual computers. More often than not, in the courts, these computers are not even networked. They're not even networked within the same court system. They have very little common packages at the application layer. That is, that they're not working on the same set of common apps, though that is growing in recent years, maybe in the last half decade. We are far away from e-filing, even in the courts that we consider e-filing courts, say Delhi High Court. Really, it's e-filing in the sense they paper and scan and then file, and then it gets printed again and used as paper by judges. This is not the concept of an e-filing system. That's roughly where we are currently. No great progress in the Supreme Court. Maybe there are a few district courts that have made progress on this question, but all said, we'd say that India is not really there. So, three ingredients I'm talking about. First, for this kind of effective reform, focus on the people. What kinds of people are going to be manning this system? Second, focus on the technology and ensure that you have a very well architected technology stack that gets the work done. Number three, look to re-engineer the courts. That is, the reason for using technology is not simply to mimic what we already have. Meaning, let's say you open a court at 11 o'clock. Now you open a Zoom conference or one of these video conferencing software that we are using today. You open this conference room and allow somebody to talk, just like they would talk in a courtroom. Now, this is one way of thinking about the problem of about the use of technology in reform. That is not the way that Singapore did it. At each step of the way, when Singapore introduced technology, they transformed the way courts worked. Right? And it's using technology as a transformative engine that really delivered the quality and quantum of reform that was delivered in the Singaporean experience. So, the first important thing that I want to stress in the first point before I move to my next point about leadership is that unless we take a 360-degree view, we will get shallow reform. India, for example, has institutionalized and spent a little bit of money on technology. We have also spent a little bit of money on people, but there's no integration between the people layer and the technology layer. So the reform, which includes court managers like yourselves, which came out of the 13th Finance Commission, was one such institutional, people reform layer. But the tying up of the technology layer and the people layer has yet to occur. In any case, the use of technology in the Indian court system has not been about, it's been about taking what we already do on paper and transforming them into a digital, kind of bespoke code development projects of NIC, which simply takes the existing practice. And I'll tell you what the proof of this is. The proof of this is that every district court has its own nomenclature for own abbreviations and own code on the software package. So all said, we have, if you want to study, for example, how a 138 cases disposed of in West Bengal versus how are they disposed of in Karnataka, tracking and organizing the cases using the data grid is a huge exercise because the classification of the case classifier category in code is different across the systems. So if we if this is the first thing that we've got to learn, that we've got to take a 360-degree view, we've got to integrate these many layers, and we've got to run this program for a substantial period of time. That's point number one. The second one is and we just can't shy away from this, it is the value of leadership. So in Singapore, Chief Justice Yong Pung Hao was the pioneer and the leader, anchor of this exercise. He was appointed in 1990. He was Chief Justice all the way up to 2006, 16 years. He singularly transformed the Singaporean legal system. It might beg the question, oh, will this ever happen in India? We know that if a Chief Justice has anything more than 12 months as a overall term, that is considered long. So 16 years seems simply out of the pale. But why is this important? It's important because the sustained energy and effort that is required to make enduring legal change, legal transformation occur is not going to happen in 12 months, no matter how brilliant the person is. Having spoken about brilliance, it's useful to just pay a little bit of attention to who Chief Justice Yong Pung Hao is. He was a lawyer, grew up in Malaysia. His father was a solicitor in a law firm, and he went on to study law at Cambridge and Cambridge University in England, came back, was a solicitor for a period of time, and then at a later stage, he moved into, he moved in, was literally hand selected to move to become the chairman of the Singaporean National Wealth Fund, I think it's called GIC and Temasek. So he played a very, very key role in the setting up of their sovereign wealth funds. He went on to become the chairperson of the Monetary Authority of Singapore. Monetary Authority of Singapore is like India's RBI. He was a lawyer, mind you, very bright lawyer. And then he got appointed the Chief Justice of the Singaporean court. Now notice the width and the breadth of experience that Chief Justice Yong Pung Hao had. And you know that in our system, we only get career judges. We get judges who essentially select members of the bar to become judges, and judges who select each other through the collegium system. This is the method of our selection. Someone with the diverse talents and energies of Justice Yong Pung Hao would not make it through the Indian system. Why was his selection important? One of the first things it appears he did when he took charge was to get rid of the wigs, get rid of the forms of address, no more lordship, my lords, all that went out of the window. Streamline the courts, very tough in court on how court time was managed right from the start, and then institutionalize these reforms. It's not just about what his personal conduct is, it is about his ability to get institutions to change and move in this direction. Now, why do I spend a little bit of time on the question of leadership? Because I think that if we don't pay attention to this critical question, who is going to lead this process and for what period of time, there is very little chance that we will get significant legal transformation going. So we have got to crack this problem of leadership in India for us to make progress. The third element that I want to focus on is just the focus on the problem of case management. And I know that most of you deal with this court management and case management. So you know that the sort of any common law system, the broad question of choice that a common law court has is to decide whether management of the court and of a case is left to the lawyers or it's left to the court. Now, a lawyer managed court cannot, it cannot then have agendas of how quickly cases finish and, you're basically leaving it to the adversarial system, leaving it to the interests of the two parties to be battled out. The court simply is a neutral umpire. It just sits back and allows the process to unfold. This is a fair description of the current Indian process. For the most part, law judges neither have the conviction nor do they feel they have the authority to be able to check the process followed in court. So essentially, we leave it to the lawyers to run the court system, and really the entire apparatus that we have facilitates this kind of process. The first thing that Chief Justice Yung Pong Hao changed is he shifted from an adversarial lawyer-led system to a court management system. And now, when you say courts are in control, and you must remember that this was also a common proposition at the same time in England, which went through the Lord Woolf reforms, civil justice reforms, at about the same time in the mid 1990s. What do we mean when we say we have a court management system? Now, the court management system can be three kinds of court management systems. The first kind of court management system might purely be, can be reasonably non-interventionist, which means we put a lot of investment in technology. We, run a very efficient registry, which I assume many of you will be involved with. But then you don't do too much more than that. Now, this is one way of doing it. The second way of doing it, and I'll call this the non-interventionist case management system. The second way of doing it is to be broadly facilitative. That is that the role of the court, we help people along. You counsel parties, you counsel lawyers, and say, look, let's try and get this done in the next 3 months, and so on and so on. The third model is to be much more managerial. And in this third model, the court takes charge not only with the framing of issues, but the court also takes charge with a very strong calendar, a calendar for disposition. And very important events in the case, the dates are decided in the beginning itself. Now, as I said to you, and I use that phrase, outcome date certainty, when we concluded the last session, the single most incentive changing act in court management appears to be the fixation of calendars. The moment parties and lawyers know that this is the way their case is going to pan out, and indeed that is the way cases are decided, it appears that courts seem to reinvent themselves completely. And this is what has happened in Singapore. They have used a managerial model of case management with differentiated case management, by which I mean every case, a family law case is not managed like the way a recovery suit is managed, not managed like the way an insolvency case is. Each case, so there's differentiated case management, but there is strong managerial case management of every case. Now you might think, my God, do we even have the time to sit and do this? This is where technology comes in, because technology gives the court standard templates to work with. The moment we decide that this is an insolvency case, there is an insolvency case template. For the most part, that template can be applied in full. There might be some variations, and the job of the court manager and the job of the judge is to do this, is to make these variations. But with a template, this process can be speeded along significantly. And this is the Singaporean experience. Differentiated case management, strong establishment of timelines at the start of the proceeding. And to this, they added a second strategy, which is diversionary. Every case that came up before the courts was pushed initially towards some form of ADR. So I know, and you know, that with Section 89 of the Civil Procedure Code, and now increasingly in other fora, there has been an attempt to do the same, to put in a diversionary element, either send it to mediation or to arbitration or to some other form of conciliation before you start the court calendar. Now, what is fascinating about this diversionary strategy in India and the diversionary strategy in Singapore is that in India, we just send it to mediation. We send it to mediation without establishing the court calendar first. In Singapore, what's very important is that once you do your pre-trial hearings and establish that this is the calendar for this case, then send it for mediation, the chances of settlement increase dramatically. Why do they increase? Because parties know that concretely, if they do not settle in the ADR setting, they will be held to the calendar already established in court. This crystallizes the interest in the mind of parties, leads to higher levels of settlement, and frees up court time. This is a huge win. It is this kind of interwoven procedural strategy that has been evolved in Singapore that has led to the dramatic transformation of the Singaporean court system. Please notice what the elements of this process. First things first, parties have come to court, filed a case. Second, a pre-trial court hearing is held. Notice that not all of these pre-trial court processes are before judges. Registrars have significant role in these processes. Initial templates are in fact generated entirely by the back office, not generated using court time. Already pre-prepared, parties review, parties discuss, and there might be a hearing before a judge or before a registry for that, and settle the calendar. Then it goes for a diversionary ADR process. And what we have found as a result is when you do this, levels of settlement increase manifold. And this process has transformed the Singaporean system. Obviously, and I've said this to you in the last session as well, Singapore imposes strong costs on parties that seek adjournments or do any delays. Singapore also expects parties to pay for the costs of court time. So the court system is not cheap. At the same time, Singapore has done many things like, in small traffic offenses and so on, the courts run in the evening, they don't run in the morning. Why? Because people are usually in office and they are free for this, the part of the day starting from 5 o'clock. And the evening courts deal with all these minor traffic and regulatory offenses, get it done with. So consumer convenience as well as effective delivery. So whenever we look at the reform, and I focus my attention on how the integrated electronic litigation system has developed very strong templates on a managerial approach to case management, right? And this is the process coupled with a diversionary pathway has led to increased settlement in Singapore and delivered remarkable results. Now, any study of a complex reform model which has succeeded needs many more layers. But for the purposes of a session like this, when we have 1 hour, and I'm going to take 30 or 40 minutes, must focus on a few elements, and that's what I have done. Now, you might imagine, and I'm going to close, I'm going to go to my last theme. So I spoke a little bit about why 360-degree approaches. I spoke a little bit about leadership. And then I focused on the method of case management that has been adopted in Singapore and why it has yielded results. I'm going to close this session by focusing on whether such an approach, strong case management, managerial case management, strong emphasis on costs, strong emphasis on no adjournments and no delays, not giving parties and their lawyers too much control over court proceedings. Will this result in justice or not? Is this just efficient court management but not just? Now, you know, and I know that in the Indian court system, there are no shortage of judges who use the language of procedure being the handmaiden of justice. I don't know, I'm sure you've heard this expression. Whenever you see an opinion, a judicial opinion, where you read something like that, procedure is the handmaiden of justice, no matter what the costs and thing, you must always give parties the ability to to raise their concerns and so on and so forth. And that is what justice requires. Justice requires an endless bending of the arc of procedure to the interests of justice. This is the way the Indian court judicial system usually frames the trade off between efficiency and the justness of outcomes. I'm going to say two things here. If this were indeed true, then satisfaction levels with the Indian courts would be extremely high. In other words, if we did a broad survey of 100 litigants before the Indian courts, because our courts are so fair and so justice leaning, then at least 70 to 75% of these litigants must come and say, we are thoroughly satisfied with the court. Right? Maybe it takes a long time, but they are very fair and very just. Is this true? The available data on litigant satisfaction with the courts suggests that satisfaction levels are extremely poor. Satisfaction levels may certainly below 50%, may even be below 30%. Why is this the case? If indeed our courts are more justice preferring than managerial and procedure preferring, why is it that we don't have higher levels of satisfaction? And the answer to this question might lie in two places. One, that the justice preferences of the judges may actually be catering to lawyer incentives and not to client incentives. Clients might actually prefer a swifter and brisker ending to their efforts at litigation. So the intermediaries, the lawyers' incentives and the clients' incentives may be misaligned, and the judges may really be speaking to the lawyers when they say that that they would prefer justice over case management. There's a second sense in which this is possibly the case, is that the justice that we need to deliver is not just between the two parties at hand. I have two parties before me, but I have hundreds of potential parties who have similar disputes that need to be resolved. The justice that I need to deliver is not just to the two parties who are in court before me, but to the potential universe of litigants who need the services of the court. Once you factor in all those litigants who are not before the court in the case at hand, then you realize that the interests of the parties in this case cannot override the interests of the parties in all the other potential cases in the name of justice. Justice not only needs to be done to the parties before the court in the case at hand, but also to all the other parties. If that is the case, then a managerial court is a good idea. Because a managerial court optimizes the allocation of resources to the case at hand and to all potential cases. This conceptual confusion between how a more efficient process is somehow justice reducing needs to go away from the Indian court system. And till we are able to push that out, that conceptual confusion, we're going to remain stuck in the place that we are. So, what are the levels of consumer satisfaction in the Singaporean court system? Extremely high, upwards of 80%. Now, here we have a court system that is slightly expensive, maybe some might say very expensive, highly managerialist, yet delivering high levels of consumer satisfaction, litigant satisfaction. So, if in India we need to think about the problem of court reform and learn from Singapore, we need to integrate as many of these insights as we can. We need to solve the problem of leadership. We need to solve the problem of executive ownership over court transformation so that we have the resources for that transformation. We need to have sustained programs of court transformation that are not left only to the judges, have strong administrative backbones to be able to run these registries in an efficient way. Technology use has to be transformative. It has to be transformative because it needs to change the process of litigation, not simply take the existing process of litigation and put it on a computer. So let me stop there. I think that with this bundle of strategies, India will go far, much further than our current processes uh, of reform that are currently under. Thank you, and back to Mr. Panchakshari.
Thank you. Thank you so much, sir. There was a excellent guidance and overall experience has been given to all the court managers. There are a couple of questions coming in.
Yes.
If we can start with.
Yes. So I can see Mr. Rajan's observation. I wouldn't put it as a question.
Yes.
So Dr. Kalpesh Kumar asked the question, what is the solution for case classification in Indian judiciary? I did work on numbers. Karnataka High Court having 594. You mean 594 case classifications, I assume, and Kerala 276 and Meghalaya 224 and so on. Clearly, this problem of case classification is ultimately for someone who is not in the court system and is an academic is a bit of a puzzle. If you think about classification systems, we have developed some pretty robust classification systems around the world. For example, in the area of libraries, we have something like a Dewey Decimal System. So this is a system which uses series of numbers divided by the decimal point. The moment you do that, you get a class and a subclass and a subclass system going. So no matter what the complexity of cases in the Indian system, you can have something like a Dewey Decimal System which takes care of it. Currently, our code process seems to prefer an alphanumeric system, by which I mean the use of some numbers and some letters. And most of the alphanumeric system seems to follow the filing numbers, right? So that is our current model of case ordering and case numbering, which generates all kinds of doubts. So I'm going to maybe Dr. Kalpesh's question deserves this distinction between a filing number, which must be a unique number for a case, that as it moves through the system, no matter how it moves through the system in the appellate bodies or whatever, wherever else in review, and we must distinguish between a classification system which orders the type of case. Both of this is necessary, but Dr. Kalpesh has also shared a paper with me, which I will certainly look at, and I'm look forward to reading it in the near future. I haven't seen this material before, but clearly the question that you raise is extremely important. Thank you. I've already downloaded your paper.
So sir, in context of Singaporean judicial reforms model, could you please provide your views on present judicial system, Indian judicial system rather, and what court managers can do? Whatever that is, when we do SWOT analysis, something there is internal which can be done by the people or the organization, and external which can be done by the external bodies.
May I ask you a small question, Mr. Panchakshari, because it will help me respond. So currently, the court manager is recruited under a special scheme. You work as a subordinate to the registrar of the court system, and the rest of the court system reports to you, or what is the administrative structure of the court where the court manager is located at this moment? This would be very useful for me.
Yeah. Earlier, the scheme of court manager was under the 13th finance was to assist the principal district judge in districts, judicial districts, and registrar general in high court. Now, at the judicial districts, the court manager will directly report to the principal district judge. Being the contractual nature of the position at the moment, the administrative setup of reporting about the staff to the court manager is still in a nascent stage. It is still not activated because of the contractual nature of the post.
Right. So you report to the principal district judge or to the registrar of the high court?
No. we are appointed by the High Court Registrar General, and we report to Principal District Judge in that particular district.
So the current court managers are only at the district level.
Yeah, they are at the district level, and in High Court, there are two court managers. In bench of a High Court, there is one court manager. Like that, whatever would be the bench, there would be one court manager in High Court, and whatever would be the judicial setup in subordinate courts, that is at districts, there is one court manager.
Correct. I understood. So from what I can tell, and I need to understand the details of the system better than what I do at the moment.
Yeah.
What I understand is that the problem of case classification would be a decision that would be taken by the Registrar General, I assume, of the High Court, and maybe at the district court level by the Principal District Judge.
Yes.
So to that extent, court managers can feed into the case classification. You can probably make a recommendation. I don't know how binding those recommendations might be, but they would be useful recommendations nevertheless. Am I right about that?
Yes, absolutely.
So it might depend on the receptivity of the particular judge or the particular registrar at hand to decide how much they would incorporate your suggestion.
Absolutely.
But what I think, and I'm going to read Dr. Kalpesh's with great interest. You know what? We need to understand why we do what we are doing at the moment better. To be able to explain to the world that the existing modes of classification and so on are inadequate and we need to move on. And making this information public information to which and allowing for a broader public recognition of the demerits of the current system is an essential first step. We cannot even imagine future change, positive change, unless there is broad public recognition and broad professional recognition that the current methods of case management are simply inadequate. That is the way I would respond. And I look forward to reading Dr. Kalpesh's paper. Maybe he's already got there and is moving along similar lines, in which case all of us should join hands in the same direction.
So there is one more suggestion I have, if you can permit me to read.
Please.
Can there be a study undertaken by esteemed institutions like NLSIU under the leadership like your good self on the subject court managers evolution, present situation, and way ahead? With esteemed institutions like NLSIU, can we, in the context of Singaporean judicial reforms model, can they come out with some model or some manual for court managers, at least what they can do? Though there are certain restrictions on a political side or on a leadership side, but court managers are part of the system now. Now, at least there can be some manual. Could you please guide on that?
Yeah, I think that that kind of preliminary work would be useful. Universities are well placed to do this kind of work. I would say that, and I've been doing legal system reform research for some time. I still don't know enough about the court manager system. So I think there is a lot to learn for even academics and researchers in this field. I can share with you that at NLS, we are in the process of setting up a legal system reform unit. And clearly, as soon as we get set up, this kind of issue would be a primary issue for us.
Excellent.
I can put that on the calendar.
Sure.
So
there is one more suggestion I have, if you permit me. Now, since we are part of the system now, to get to be updated on latest trends, new innovations in the field of law, and to bridge the gap of academy and practice. It is a request if NLSIU can start yearly workshop for court managers to update and upgrade their knowledge from the Temple of Justice, that is NLSIU. If that it is just a suggestion, sir.
Yeah, I mean, we could do that provided we have the right kind of knowledge. I feel that your field, the court manager's field, is a highly specialized field. It is at the junction between court procedures as prescribed in procedural laws and the managerial bureaucratic processes that have been
Right.
developed by these institutions.
Right.
This is much of this knowledge is internal knowledge. It is
Right.
not knowledge that is well spread out in the world. So I think that we should definitely invest in understanding that situation better. I would say these are medium term objectives. They are not short term, because I can't think of a single paper even addressing the question that Dr. Kalpesh has addressed in his case management paper. Now, I know people who have similar intellectual concerns, but we have not written about it. And the reason we have not written about it is because we don't understand it very well. So I think
Right.
there is a little bit of a understanding gap that we as academics and people interested in these public policy fields, we have to bridge those understanding first before we are the ones conducting anything. But what I think is that even an annual, and I think you are already doing it with GNLU. I looked at your website. I'm very
Yes, sir.
excited to see that.
Now, uh, the we cannot call it as an issue, or we cannot call it as a since everything is new. Earlier we were new to the system, but now we have adopted to the system. Now we explore the avenues wherein we can get the latest knowledge or latest trends on management, on legal reform. So in that sense, it was a request if we can be a part associated with the.
We can also, play another important role vis-a-vis your work, which is that we are in touch, and many of my alumni lead the most innovative legal tech companies in the country, in the
Right.
country, doing all kinds of innovative legal technology. So to that extent, we can also play a part in connecting you all to these tech companies, because they can learn from you and you can learn from them.
Absolutely, sir. That is a wonder. Like, yeah, a day. I think last Thursday we have had a webinar from Deputy Chairman, Justice R.C. Chavan, sir. Even there also, this particular thought has evolved. That is, court managers being a think tank for e-committee, at least to begin with. Though we are not explored the duties and responsibilities assigned to the court managers, but to begin with, whatever is the current situation, considering that and keeping other things constant, to begin with the present situation, we requested, okay, at least whatever e-committee is doing, e-committee is coming with new, or they are coming with new innovative, at least to begin with, they are coming with technology driven process, technology driven manuals. You make us part of it.
Yeah.
To
I
begin,
think
that is what we
that's a good
suggested.
idea. I see Mr. Rajan's comments on the chat, where Mr. Rajan points out that ultimately the adaptability of the court manager to the particular court depends on the disposition of the principal district judge, maybe the disposition of the registrar general of the High Court, and so on. And I think that developing a standard protocol that understands what is the location of the court manager vis-a-vis the existing registry functions of the court might make a huge difference. I see the value of that. And I take it that this can be stated pretty explicitly and clearly, so that all courts are able to utilize the services provided.
Right.
I also see that Dr. Ananda makes the point that in an adversarial system, I think his comment is that, can the case management system improve and reform as those are not directly contributing? Yeah, no, I clearly the time has come in the country where we need to move away from the idea that an adversarial system means that lawyers control the court process. Unfortunately, it's only in India. In India, people seem to think that adversarialism means that lawyers can endlessly control the process. Which other country which would call itself an adversarial system would allow that? In the United States Supreme Court, oral argument, even in the most complicated case, only for 45 per side. No, you are deciding life and death issues, you're deciding the future of who remains the president of the United States. Still, you have oral argument time of 45 minutes. That is also an adversarial common law country. So how is it we have come to understand in India that oral argument can go on for days together, whether that be in the trial stage or in the appellate and court stage? We need to move away from that. And I think on that, I think most right thinking people are agreed. But clearly the judges need to appreciate the point and the lawyers need to appreciate the clients would be very happy if judges gave everybody defined periods of time and made decisions. Clients would be happy. Lawyers need to come along and judges need to come along. Managing the transformation of these two institutional spaces that's the
Abs-
challenge.
Absolutely right, sir. Absolutely right.
So what is interesting is that, and I want to just mention this as an aside, that in Singapore, they incrementally changed everything. They changed the court rules of practice. They changed the procedure code. They changed the registry function. So they changed all of this simultaneously in tandem. And more than anything else, I want to emphasize they invested in knowledge. This was not done in some, I don't know, I'll use an Indian expression. It was not done in a jugaad style. So they actually, before they changed a simple issue like how is notice and summons served? Notice and summons serving, they went into it in detail, looked at existing procedures, made proposals on what needs to change, tested it in one or two courts, then scaled it up across the courts. This is the way to do it. This is what
Sir,
enduring change is about. Some investment in knowledge and understanding, some experimentation, and then scaling up.
absolutely.
This is the same pathway we must follow. There is
Right.
no other magic. The magic is in the rigor of the process. It cannot be done on a whim and fancy,
Mhm.
not in public systems.
The Singapore has a Singapore Academy of Law, which has transformed the legal system in Singapore. Similarly, there are de- the developed countries have national court administration departments. Sir, can't we have such academies in India who can be guiding, who will be guiding or experimenting on new approaches, new legal innovations, and putting, after doing all the tests and successful tests, they can put into the practice into the courts, something like that?
In a way, Mr. Akshari, the National Judicial Academy and the state judicial academies were partially imagined like that. They were meant to be in service training for judges and in service training for judges across the spectrum from the lower courts to the high court and the Supreme Court.
Right.
And they were meant to be engines of legal system transformation. What have we done? We have created these institutions where we have built big buildings. We run some training programs. I'm not suggesting that the programs are not. Certainly, they are not engines of legal reform transformation. They don't do any research,
Right.
worth the name. They don't do any structured. Still, we have an institutional space that we call the National Judicial Academy. judicial academy. Till they realize that their role must be like the Singapore Academy of Law,
Right. Right.
I think that that impoverished imagination of what these academies can be limit. I don't think, to be fair, these academies have reasonable resources. They're not
Right.
they're not very underfunded. They're reasonably funded, but they need to fix on this agenda as being their agenda. They are best placed to do it. What is
Right.
the? I'll just say one last sentence. Sometimes I feel that this initiative has to come from the Indian university system. If it doesn't come from the university system, if it comes from within the judicial system, I don't know how well it is going to work. My is my instinct, and I've been looking at these structures for some time. Either the judiciary is willing to make judicial academies, let them be headed by academics,
Okay.
staffed by academics who are committed to legal system transformation,
Reforms.
or they should just create new entities in these in universities whose sole mandate transformation.
Okay.
These seem to be viable pathways.
Okay.
I see that Dr. Rasika, and maybe we can treat that as it's 410 now as the last question, about ADR processes in Singapore courts. So I think you understand that in India we have now started to experiment quite seriously with what is called a court managed or court annexed mediation and arbitration. The results of these court annexed mediation arbitration centers have been reasonably positive, but not revolutionary. Now, in Singapore, they and we just were discussing the role of the Singapore Academy of Law. Singapore Academy of Law has become the hub of mediation and commercial arbitration, international commercial arbitration. And for that matter, in Southeast Asia, and I think many of you know that even Indian commercial parties prefer mediation and arbitration in Singapore to mediation and arbitration in Bombay. And what I find fascinating and insightful is that many of these parties will tell you that the total cost of arbitration and mediation in Singapore is cheaper than India. Ad hoc arbitration in India is so expensive because it goes back into the same practice of judges doing multiple arbitrations at the same time, and they have governments, and fee sitting has hearing fee and reading fee and writing fee and so on and so forth. Ultimately, the Singapore arbitration system is able to deliver a result at a lower cost than the drawn out Indian arbitration system. So we have a situation when we look at the ADR process in Singapore. I won't say ADR process in Singapore courts, because these ADR processes are not always in the same court system. They are in independent bodies. We must create independent bodies of mediators, independent bodies of arbitrators, institutionalized. Ad hoc mediation, ad hoc arbitration is the bane of the Indian system. Mediation is reasonably institutionalized. Arbitration is not institutional. Ad hoc culture continues. Now the creation of these court related arbitration centers, we'll have to wait and watch and study them. Arbitration court attached arbitration centers are relatively new. Mediation centers, I have myself studied and published on mediation center. So, and the results are pretty good in the mediation centers. But unfortunately, mediation in places like Karnataka and Bangalore often get thought to be places where you send family law cases to. You don't want to send your partition suit to mediation. You only want to send your family law case. Now, this is a category mistake that we make. Even the partition suit.
Okay.
We don't do that. these are just a few key differences that I'm highlighting. I'm not making a full response to Dr. Rasika's question.
Anyway, with the paucity of time, I must thank you for giving us a wonderful feast for the Sunday afternoon.
Thank you.
The 360-degree approach, the leadership and case management and court management ingredients of the Singaporean judicial transformation. You have guided us so excellently. I must thank you on behalf of all the court managers. Now I request Dr. Atul Jhende to give vote of thanks.
Very warm good evening to all of us here. And once again, most of the half of my work is already done by the Punch. Thanksgiving, he has covered all technical parts what I was supposed to cover. So, what I would like to mention here to Professor Dr. Honorable Krishna Swamy sir, that he has assured last Sunday that he'll be available again, and since I understand he was about to catch some pre-assumed program, still he made available this Sunday to all of us to enlighten our thoughts. And for that, I just wanted to mention a very sincere applauses from our end that this is one of the, again, one more outstanding webinar to understand the cross country, out of the country culture of the court system. And with this, we will take this forward for whatever daily lives court administration we are supposed to do. With this note, I thank organizers. Thank you, Krishna Swamy sir, and all the painstakerers, as well the JNLSIU technical staff and all of those people present there who have made this platform available for us. Thank you once again. Thank you.
Thank you very much.
Thank you. Thanks a lot.
Thank you.